Hey, I think I will go ahead and address that first question. I'll address it again. Somebody's asking if you'll receive a copy of the recording. The recording will be available on the State Bar of New Mexico's website, which is if you either Google State Bar of New Mexico or it's sbnm.org. And if you go to the For the Public tab, it has the Modest Means Helpline listed, and it's in there under our publications. So it's for the Modest Means Helpline is is the hosting entity, and it's on the Modest Means Helpline webpage. So welcome everybody. I am going to officially start now. My name's Casey Daniel, and I'm the managing attorney for the Modest Means Helpline. I'm also the legal services director for our State Bar Foundation, which has it's the arm of the State Bar that has all the programs that help the public. One of those being the Modest Means Helpline, which is a civil helpline, free to the public for folks that are under 500 or less of federal poverty is their income. And we handle civil matters. It's a telephone helpline, so everything that we do is over the phone. And we also have the ability to refer cases to pro bono attorneys if they meet the criteria, which is basically if the issue is something that you really need, the person really needs more than just legal advice, and there's some compelling factor why they would not be able to represent themselves in court, and then see that a pro bono attorney would actually take that type of case. Most of their cases are family law cases. We have a lot of family law domestic relations cases. Our second most common is landlord-tenant. We also do small business issues and consumer and probate cases, and then just in general, a bunch of other things. And today, our co-presenter in the person who's basically going to be taking it from here and giving you the bulk of the information is Larry Donahue. And I'll let Larry introduce himself. And then just the other name on there is Mia Lorenz. Mia is a staff attorney with the Modest Means Helpline, who does take the small business calls. So Larry has been a friend to our program since its beginning over a year ago. Super generous with his time to us and helping us with small business issues, and has helped us with our past webinars. You can find all of our past webinars on the Modest Means Helpline website, which is embedded within the State Bar of New Mexico's website. And so, Larry, I'll let you, if you want to go into detail about your business and what you do, that would go for it.
Thank you. I appreciate it. And thank you for hosting this. I appreciate you inviting me and letting me talk about this, I think, interesting. I think everybody else is going to think boring and annoying topic. I do want to say, my name's Larry Donahue. I am the founder and principal for Law for Small Business and Business Law Southwest. We're one law firm, but we have two different brands. And the reason for that is we do a lot of business on the internet. And so that's the Law for Small Business brand. And the Business Law Southwest brand is more your traditional law firm. And so we do a lot of, it's all business, but transaction work as well as a lot of litigation. And today we're going to talk about the Corporate Transparency Act. And I'm not going to hold the great information to the end. I know we're all professionals. And if you're in this, you're tuning into this, you probably have some sort of relationship to a business, small business. And so I'm going to give you everything you need to know on the first slide. And then we're going to go into a series of different rabbit holes and, more in depth on a bunch of different topics. But if, you have to leave early, that's fine. You'll get a lot of good information up front. And then I'm going to go into more detail in different areas as we proceed. I'm going to go a little fast, and I apologize. There's just a lot of material here, but we will give you access to the slides and the presentation after this, so you can certainly review and go back. The other thing I wanted to mention is questions. I love them. Please feel free to interrupt me. You can use the chat or the Q&A. Put your questions in. I'll watch for them and I'll answer them on the fly. And then I will move accordingly to make sure that we get this finished within the hour. With that said, this is the agenda. I'm gonna give you everything you need to know on one slide, and then I'm gonna focus on two major questions. One is, do I have a reporting company? Is it a company that needs a report? The quick answer is yes. But there could be some exceptions, and we're going to talk about those. The second big question is, who are my beneficial owners of the company? And that is a harder question to answer than you might think. So we're going to spend quite a bit of time talking about that. And then I'm going to go through some just administrative nonsense about how you actually have to submit and where you go to do that. And then if we have some time at the end, we'll open it up to more questions. But hopefully I'll answer your questions as we go through this. So let's on to the first slide. The Corporate Transparency Act requires all beneficial ownership information of companies in the United States submitted to a specific database managed by FinCEN, which stands for financial, I don't know, I don't remember. You can look it up on Google, but it's basically affiliated with the Treasury Department, and it manages and deals with financial crimes and enforcement. And they will have a centralized database for this information. And there's two important dates that I have listed here. If you formed a company from this last January 1st, you have 90 days to submit the beneficial ownership information and of the company and its beneficial owners. You have 90 days to do that. If you have a previous company formed, meaning it was formed prior to this January, then you have until the end of the year, basically January 1st of 2025. And I want to say shout out to Sandy, by the way, who helped me with FinCEN. It stands for Financial Crimes Enforcement Network under the Department of Treasury. Thank you, Sandy. The big issue here is all companies have to report by the end of the year. And that's the deadline. Got to get it done. And as of January 1st, 2025, I said any new companies have 90 days to submit. That 90 days shrinks to 30 days. So you have 30 days after January to submit. And if you have any changes to the beneficial ownership information or the company, you have 30 days to submit as well. And where do you file? This link, fincen.gov/BOI. That's the link. It has a lot of information. And I'm going to tell you within there, and I'll explain this a little bit further, but they have a really good small entity compliance guide. And I would recommend you review that. There's going to be reasons for that depending on the type of business you have. And I'm referencing that heavily. And I do that not just because I'm lazy, and I am, but I also am doing it because, at least for my small mind, I need to see things several times for them to stick for me. And so I'm trying to do that for you. So I'm going to share with you some of the same graphs and information in the small entity compliance guide so that if and when you reference that, you'll see it a second time, and hopefully it'll help stick for you. But I mentioned this, all companies have 30 days to update their information. And here's the big problem. There are criminal sanctions up to 2 years in imprisonment and fine up to $10,000, as well as civil sanctions of $500 a day for not filing on time or filing false information. So you need to treat this seriously, unfortunately. And before you shoot the messenger here, I hate this as much as anybody else. And we can't really blame a specific president or administration. This has been an active thing on both sides of the aisle. It started back before the Obama administration, and each administration going forward has had a hand in this. And then it was also passed in Congress from both aisles. So this is a thing I think we're stuck with. So who are the company's beneficial owners? The quick answer is anyone who owns or controls 25% or more of a company. And this can include employees that have options in a company, meaning they don't actually have an ownership interest today, but they could have an ownership interest in the future. They could be considered beneficial owners, and you have to look at all the potential ownership when you're calculating these numbers. The other component of beneficial owners are anybody that has what's considered a substantial control in the company. They don't have to be an owner. If they're a C-level executive, for instance, they're a member of the board. If they have important roles within a company, they can be considered beneficial owners as well. And I think that's going to get a lot of people into trouble, because are they a beneficial owner or not? I think the advice here is to assume so, unless you're going to consult with a lawyer and get a legal opinion on the matter. Assume that somebody in your company that's making decisions is probably a beneficial owner for BOI reporting purposes. What must be submitted? There's really two categories. One is information about the company, and then information about each beneficial owner. For the company, they want the full legal name, any DBAs, the jurisdiction or jurisdictions, plural, where it's operating, meaning what states or Indian tribes or territories, the complete U.S. address, as well as the tax ID number. For the beneficial owner or owners, we need all of this listed here: the full legal name, the date of birth, the complete address where they call a residence, a photo ID, and they have very specific requirements on that. It has to be a valid, meaning non-expired, passport, state driver's license, or government-issued ID. That's it. Nothing else is going to work. Student IDs are not going to work. Gun cards aren't going to work. You know, this is it. Those forms of ID and nothing else. So finally, where can you get more help? These links are really important. The first one is the Small Entity Compliance Guide I mentioned, and I'm going to steal heavily from in this presentation. It's located at the fincen.gov, and here's the link for it. I'm going to show you exactly where on the website in a minute. The other thing is this is a little bit of a self-plug. I'm a software developer, and I wrote an expert system that took the Small Entity Compliance Guide and coded it. So if you don't want to have to read the 59 pages or whatever it is, you can use our software for free to get access to answer those two important questions. Do you have a company that needs to report? And then if so, who are the beneficial owners? That software will answer those questions for you. The problem is, it's not always an easy thing to answer. It's going to depend on stuff you may not know about your company, including its tax status. Do you have different classes of ownership and so on? But we're going to dive into that as we go forward in this presentation. So here is what the FinCEN website looks like when you go to fincen.gov/BOI. And what I'm trying to, from there, you will select reference materials, and then the Small Entity Compliance Guide that I've just pointed to here. That's, if you're not going to read anything else, access that document. This is the BOI Labs I talked about. If you go to solutions, and then at the bottom, it's called the BOI Evaluation Tool. It's free to anybody that wants to use it, and it will give you, frankly, I'm tooting my own horn. It's the best expert system out there right now. And we're going to continue to update it and keep it compliant with the FinCEN rules, with the goal of helping people understand how they comply with this so they don't have fees and penalties and dealing with all of that stuff. So with that, let's go into a little bit. And by the way, if you need to go do lunch and you're like, I don't have much time to listen to this guy prattle on, I've told you the important information. So now we're going to go into more detail on things. So you can take off if you want to, and you can get access to the presentation later. But if you're interested in listening to me prattle on about this, then I'm going to dive right in, and we're going to answer the first question. Is my company a reporting company? And the answer is probably. This flow chart here, I don't remember what page it's on in the FinCEN guide, but I copied it exactly from the FinCEN guide. It's chart 1, and it takes you through the flow chart of determining whether you have a company that's required to report. The quick sort of summary of this is, if you have an entity that's registered with the state, or an Indian, they call it Indian tribe, but you know, the nations and pueblos and jurisdictions managed by Native Americans, as well as any territory in the US, would be considered an entity that has to comply if you're registering with any of those jurisdictions. That includes foreign companies that end up foreign filing in the United States. So all of those companies have to file. So if it's a corporation or LLC or other entity, yes. And the only reason it would not have to report is if it follows one of these exemptions. There's 23 of them. So these companies, these groups are going to be the stuff that you would imagine are already known to FinCEN or the government somehow, like credit unions, banks, government authorities. What I'm going to do a little, we don't have enough time to dive into all of these, unfortunately, but I'm going to dive into these two, number 21 and 23, because I think there's a change. Now, the other one is I've had some people, tax exempt entities, come to me as well, and I apologize. We're not going to cover that here, but it's in the FinCEN guide. And it's going to, we'll talk about the 21 and 23, and you'll see how it might apply to tax exempt entities. But my point is, you can't just read this list and say, oh, I'm a tax exempt entity, I'm okay. You can't do that. You can't say, oh, I'm a large company. There's requirements. And so specifically with a large entity, there are 6 requirements here. All 6 must be met. And what I've done is, if you want to skim this, don't read the whole thing, just look at the bold underline. Those are the big things, and I'll summarize quickly. And that is, you have to have 20 or more full-time employees in the United States. If you have 100 employees and 90 of them are overseas, this doesn't count. You also have to have $5 million or more in net revenue, meaning net of returns and allowances, as reported on your Form 1120 or 1120S, 1065, that kind of thing. So, and it's US-based income as well. So if you're a $5 million company, but half of it's coming from overseas or Mexico or something, it does not qualify. You're not a large operating entity. Now, nonprofits, they have a different set of criteria. It's not 6. I don't remember off the top of my head. I'm sorry. But I want to say it's 3 or 4 requirements. And one of them is you're registered properly with the IRS. But another one is it had to have been for some period of time. And I want to say 12 months, but it could be less. But that specific information will be in the small entity compliance guide that I mentioned. So if you're a nonprofit, go look at that guide. They'll have the very specific requirements and reference to the statutes defining what a nonprofit is, and you can use that. So inactive entity, I mentioned we're going to talk about that as well. There's another 6 criteria here that all must be met in order to have an inactive entity. And the big one, well, there's a couple of big ones here, really. One is can't have any foreign ownership in it at all. 2, it can't have any assets whatsoever. So if you have a company that owns a piece of real estate and you're not doing anything with the real estate, it doesn't matter what you're doing with the real estate. What matters is, does the company itself own an asset, like some real estate? And if so, you don't qualify for the inactive entity as well. Finally, you see the $1,000. You can't move money in or out that's more than $1,000 within the past 12 months. Otherwise, it's not considered an inactive entity as well. So my advice is, if you have an inactive entity or an entity you're not using anymore, maybe consider dissolving it. Now, there's some issues with that too. So I don't want you to think, oh, I'm just going to dissolve my inactive entity or my company and I'm going to be okay because I don't want to deal with this. You want to be careful with that, because think of a company as a trash bag. When you dissolve that company or the trash bag, the trash doesn't disappear. It falls down on your good, nice floor and on your feet. So you, in the LLC is kind of the similar kind of thing, where if it has liabilities, it has potential issues, you dissolve the LLC or corporation or whatever entity you have, now the liability could attach to you personally. And in New Mexico, the statute of limitations for written agreements is 6 years. So if there's any possible contract dispute that might hit you, you want to consider having that entity hang around for at least 6 years. So don't dissolve companies willingly. You need to really think about the issues. So that's it for the first question. Does my company need to report? I don't see any questions here, but if you do, please throw them in. I'll be happy to answer them. But I'm going to jump now to the second question. Who are the beneficial owners of my company? And in order to answer this question, we have to ask more questions. And I hate that. I hate when people, I ask a simple question and then I get a question back. It's like, why can't you just give me the answer? And this is one of those things, unfortunately. But the first thing we have to ask ourselves is, what is an ownership interest? What kind of ownership interest does the company have? And who owns or controls 25% or more of the ownership interests of the company? And we also have to ask about substantial control. What is it? Who exercises it? And then are there exceptions? And the answer is there are, but those exceptions are pretty narrow, but we're going to talk about some of them and who would qualify. So the first question is, and actually I did it in reverse. I brought up substantial control as the number 2 piece, but I'm going to address it first because it's kind of the easiest. The harder piece is the ownership or control of the company. So on substantial control, this was pulled from chart 3 of the small entity compliance guide that I mentioned. And there's sort of 4 big areas here. And the one is senior officers. So these are the folks with the name, title, or the level of control they exert over the company. These are going to be presidents, managers, CFOs, COOs, CEOs, general counsels, that sort of thing. Would a chief human rights officer qualify as a senior officer? I don't know. FinCEN doesn't mention it in this first upper left box, but they do have what's called important decision makers in the third box in red here in the middle. And those are people that make significant decisions around business, finance, structure. So maybe is the answer. And I know nobody likes maybe on something like this. So I would probably default to yes. Somebody with a C-level position, no matter what it is, probably should report. So I mentioned the 4 categories: senior officers, anybody with appointment or removal authority, by the way. These are people like managers of a company or an LLC, possibly. Anybody who can remove or appoint senior officers or a majority of the board. The important decision makers here is the big one. And it's anyone who directs or determines or has substantial influence over important decisions. And we have a question here. Is there a penalty if you include an owner in error, as in 3 LLC members include all 3 when one doesn't actually fit the definition? No, I don't believe there are any penalties for over inclusion, if that's what you're asking. I will tell you, however, though, it benefits you to have as few beneficial owners as possible. And the reason for that is we have to do updates. And this is I'm going to talk about this a little further on, but updates are a huge pain in the butt. And when do you have to do an update? Well, anytime we make any change to the company. Okay, that doesn't matter a number of beneficial owners, but any change to a beneficial owner, if a beneficial owner gets married and changes their name, if they move their residence somewhere else, if they use an ID like a driver's license that expires, you need to resubmit. So if you have a lot of beneficial owners, you got to keep track of all of that stuff. And I think that is where people are going to get themselves into trouble. Also, this is we have a lot of clients across New Mexico, and there are a few market segments that seem to give me, Larry the lawyer, the most fits. And one of them may not come as a surprise to you, but it's the cannabis owners. And they, for whatever reason, I think they're hobbyists, they're into business, they brought their friends into business, and guess what? They're great friends when they're dealing with a hobby, but they're not so great in business, and they're getting themselves into terrible fights. And we are seeing that, beneficial owner, friend, partner A doesn't want to give his private information to the company to report. And so now we're going to have a huge fight over something like that. So it'd be really good to minimize that as if possible. So let me get back to this and I over answered your question. I apologize. I do that. We also have a catch-all, and this is basically trying to get any other form of potential substantial control over the company. And so this is where I say, if you're not sure, assume yes, assume that you need to report somebody. And we talked about decision makers a little bit. FinCEN goes into more detail on what that means. They ask questions like, are they determining business lines or ventures or geographic scope or focus? Here's an interesting question I got from somebody in the restaurant business. Is a general manager of a restaurant somebody who has substantial control over the business? And I think the answer is yes. If they're determining what is going on the menu and what items would come off the menu, or they're determining what vendors to do business with, I think they're probably, have substantial control over the business versus somebody that's maybe managing schedules. They can't hire or fire anybody, then maybe not. But it's a very fuzzy line that's very difficult for us to give exact answers at this point in time, unfortunately. There's all of this is in the FinCEN guide, by the way, but structure makes sense. If somebody can go and decide mergers and acquisitions and reorganize, clearly that's somebody of significance in the company. Finances, maybe less so. Controllers, accountants, CPAs, bookkeepers, do they have substantial control over the company? If maybe they're helping determine budgets or they're enforcing what money is being spent where, then probably. If they are simply, managing the chart of accounts, keeping track of receipts, maybe even printing checks, but not signing checks or approving checks, then maybe not, probably not. So the important takeaway here, though, is beneficial owners aren't just owners in the traditional sense. They can be folks that have a non-ownership interest, like, the C-level executives that I pointed out. So that was the easy part. And we're already 30 minutes in. Now let's talk about the hard part, the actual beneficial owners. And actually, we got another question here. Julianne asks, who in the company is allowed to do this reporting? Is it signed by the CEO, and who is authorized? Wow, what an excellent question. And the answer to that is, I don't know. FinCEN doesn't say. They just say the company shall. So I assume that means somebody that is authorized by the company. And so that can surely be, somebody you hire like Larry the lawyer, or it could be a designee, an executive assistant or somebody in the company. What you want to make sure they do is they do it accurately. And then, of course, they protect everybody's personally private information, or PII. Or I said PPI, personally identifiable information. So you want to keep that secure, by the way, as well. And then when you got to do these darn updates, you may have to go and reacquire that personal identifying information again when you do a new updated report. So ownership interest is a big problem as well. Now, a lot of small companies, maybe this isn't a big deal. It's you have 3 owners and that's it. But I want to warn you, if you look down in the middle and near the bottom, options or privileges, what this means is people who could have a future ownership interest count for the calculations. What would that mean? Employees that are given options would qualify. And you have to account for those when you calculate who owns a 25% interest or more. Another one would be a convertible note. And I picked on a cannabis, and I shouldn't be picking on them. They're an easy target, honestly. But they're doing weird investment deals, where they'll get friends or family to invest in the company, and they'll have this quasi convertible note where they'll tell their family member, if the company starts making money, we'll share the profits. But if it doesn't, we'll get your money back somehow. Trust me. Well, guess what? That's a convertible note, roughly. And so what that means is that individual, that family member doesn't but could have an ownership interest in the company someday. Guess what? You need to account for that in the calculation of beneficial ownership interest as well. So there's 5 categories I mentioned. In the equity stock voting rights, that's the first one. Now, there's capital and profit interests as well. In FinCEN, they assume people don't have these really unique creative entity types. But what this is trying to say here is, even if you have an owner that doesn't have any voting rights at all, they are still counted here. So this isn't just about people who have voting interests or voting rights. This is about anybody who has either a profit, revenue, or voting interest or control over the company. So that's also going to include the convertible instruments I mentioned, and the options and privileges as well. And then finally, there's a catch-all. And what this is trying to do is say, if you got like a little like a, nudge, nudge, wink, wink kind of verbal arrangement or deal, that's covered here as well. So if you had, and I'm not exaggerating, I get this call probably every day. Somebody says, look, I want you to be the nominee for my company. And first of all, that's illegal based on most of the definitions I see on the internet and the IRS. But there's nominee services out there that you can buy. And what is that? Well, they'll say they own the company, submit the documents, and then they'll resign from the company, leaving this false information on the Secretary of State's website. Well, the problem is the statutes and the regulations require you to keep that information up to date. So the nominee isn't doing anything for you other than creating an opportunity for my litigation department to pierce the corporate veil and go after the individual owners. So nominee services and things like that are ridiculous. Don't do them. But I get those requests and they're like, well, can't you, own the company for me? And then you'll just, as my lawyer, do what I ask you to do? And the answer is like, hell no. I wouldn't do that for my own mother. Not that I don't trust her, but, she might make stupid decisions or something like that I'll have to live with. And if anybody is asking that of you, the answer is hell no. Okay, do not get yourself into a problem like that. So I see this happening a lot. It's a big problem out there. Anywho, so there's really kind of 3 types of owners in a company, really 4, but we're going to talk about 3. And the typical one is an individual, but companies own companies, don't they? And so how does that work into all of this? We're going to go into detail, but the quick answer is a company, you need to know what their beneficial owners are. Let's call that the owning company. And then those beneficial owners own the reporting company pro rata according to the ownership interest of the owning company. Is that a mouthful? We'll go into more examples in a few minutes to explain what I mean by that. But the beneficial owners of the owning company can be excluded if the owning company is an exempted entity. And I'll give you a quick example. I mentioned government entities was one of the 23 possibilities. So imagine, for example, that maybe the city of Albuquerque is investing somehow in your business. Well, we don't need to know who the beneficial owners of the city of Albuquerque are. We can simply report city of Albuquerque has an ownership interest in the company without going into further detail. But if it wasn't city of Albuquerque, it was mom and dad's LLC, and they don't have an exempt entity, then we need to report mom and dad as beneficial owners if they meet the thresholds. So we'll go into a little bit more detail on how to calculate that in a minute. The third type of owners you might see are trusts. And I'm seeing a lot of misinformation on the internet about this. It drives me nuts. But you get people that have no experience whatsoever in legal or accounting. They just, I set this up. Isn't this great? You should do it too. And it's like, maybe talk to a professional. But trusts have a big problem here because the trustee, the beneficiaries, the grantor settlers, those can all be considered beneficial owners of the company the trust owns. So it's even worse than companies, but it depends how much control these individuals have over the assets of the trust. That's the big litmus test here. So trusts in general aren't a mechanism to bypass this. Typically, the trustee and the beneficiary and so on are going to be considered beneficial owners of the company that the trust owns. They don't own the company directly, but they have what's called an indirect ownership interest and have some level of control over the company. So there is direct and indirect levels of ownership. And direct is what you think it is. You know, if you own 5% of a company or 100% of a company, that's what you own. Direct ownership is always going to equal 100%. But indirect is through an intermediary. I mentioned the trust a little bit ago, and I mentioned mom and dad's LLC as well. So you can have mom and dad have their own company that is helping you, and they own your company to some extent. So your mom and dad have what's called an indirect ownership interest through the intermediating ownership company. And that can create interesting issues. One of them is the amount of indirect ownership in a company can be much greater than 100%. And I'll kind of show this with some of the examples we have in a minute, but it can be confusing. So a company always has 100% owners, but it can have more than 100% when we're talking about indirect relationships. So I'll give you actually one example here. Let's pretend you own 50% of your company and you have a trust that owns the other 50%. So you own directly 50%, but the trustee, the beneficiary or beneficiaries, grantor, settlor, all are considered beneficial ownership or have a beneficial ownership interest in your company because of the trust. And the trust owns the company 50%. Therefore, the trustee is considered to have a 50% indirect ownership interest. The beneficiary or beneficiaries have 50% themselves as well. In my example, it totals up to 200%. I have a new question here from Christopher who asks, how about husband and wife? If the husband is the sole member of the LLC, do we still list the wife? Well, and that's a great question, Christopher. And if I sound like I'm being snarky, I'm just trying to be funny, and I'm not funny at all. And I'm 56 and I haven't learned that lesson still. So I apologize ahead of time. But I think you proved your case. You said the wife does not own the LLC. So she's not a direct owner. So now let me ask you, does she have a C-level position in your company? Does she have some sort of substantial control in the company? Then maybe she would be considered a beneficial owner through the substantial control piece. So it's hard to answer the question exactly without asking you a lot more questions. Oh, you said she's the business manager. So if she's making important decisions, then yes, she's a beneficial owner. She may not directly own it. She may not have the tax issues or obligations, but she's probably going to still be considered a beneficial owner for FinCEN purposes. Carolyn asks, are you getting clients streamlining, minimizing ownership for smaller companies going back to sole proprietorships? Great question, Carolyn. And I'm getting a lot of questions, but I'm not seeing a lot of people doing that. And here's why. There are three primary benefits for having an entity, a corporate entity. Benefit number one is liability protection. So if you go back to sole proprietorship, you're losing all the liability protection that you would have, and you could be personally liable for debts, obligations, fights, gross receipts tax not being paid properly. So it's really risky to do that. The other two benefits I think are really interesting. One is tax. You get tax benefits by having a corporate structure, depending on how it's taxed, which you're not going to get as a sole proprietorship. And then finally, the third one is survivability. If heaven forbid something happens to you, you die or become incapacitated, your sole proprietorship dies with you instantly. It has no more credit. It loses its bank accounts, everything. If you have a corporate entity, that's not the case. It continues to exist. And so it's really a great mechanism if you have employees or family members that are depending on that business and the livelihood because of it. So let me keep going. And those are great questions, by the way. So there's really three ways to calculate ownership interest. And I'm quoting now the FinCEN guide. And I'm going to go through this quickly. And I do apologize because we're not having a ton more time left. But the first is assume all options, privileges, future ownership is part of the puzzle now. So if you have employees that have options, if all employees had exercised and vested all those options, what would the ownership be? That's the question you need to ask yourself. And then, does it issue shares like a C Corp or S Corp? And if so, does it have different levels of ownership with voting or value levels? If so, you got to look at the value of the company as well as the power, the voting power that you have. And then you take whichever number is greater in this calculation. And this is pulled directly out of the Small Entity Compliance Guide. Specifically, voting power or ownership interest is a percentage. It's based on your total versus the total within the company. So for instance, if you own 25 shares in a company that has 100 shares, you would have 25% interest. Now, if your voting changes, meaning you have two classes of stock, one class, you get double the votes, you got to account for that. And you got to put all the calculations together. The other thing is you need to know what the value is. And a lot of businesses don't know that. So that could create a potential problem for you. You need to get a fair market value, not just something that you dream up in your head. So if you do not have different levels of classes or voting, then you don't need to worry about the value at all. You can just pretend that box doesn't exist and we just focus on individual voting power and calculate that. So now finally, I talked about capital and profit interest, the partnership model. What FinCEN says here is you look at your total capital and profit interests divided by your total versus the total in the company. What they're doing here is they're trying to capture those voting interests. Let me rephrase that. The profit interests that have no voting rights. So even if you have owners that can't vote, they still apply and you still have to factor them in when you're doing your calculations. And then finally, there's a fallback. And the fallback says, if you have different levels of classes, you don't know the value, you just look at every class and who has 25% more, 25% or more voting or control in each class would then be identified as beneficial owners. And when I say this, remember, I'm talking about direct and indirect ownership. You got to look at both of those numbers and add them together to get an idea of the total that would fall out with the 25% threshold. Fun stuff. I know you're riveted, aren't you? This is good stuff. Okay, so let's go through some examples really quick. I'm pulling this from the FinCEN guide, and the FinCEN guide that I mentioned goes into more detail on how all of this works. But example number one, somebody owns 100% of their LLC and they're a president. They're going to have to report. I hope that one was clear. This one's a little bit different, a little more complicated. You have a company or corporation, and you have 4 individuals. Individual A and B, they own 50 and 40%, and they're circles. Circles mean they have to report. The triangle says doesn't need to report. And the reason individual C doesn't need to report is because they own below the 25% threshold. Finally, individual D doesn't have any ownership interest at all, but they're a president, so they have to report as well. Christopher asks a question, what if there are no members listed on the LLC? That's the third party registering. That's the third party registering the LLC thing. I'm not exactly sure what you mean by that second sentence, Christopher, but LLCs, they have to have owners. Those owners are called members. Those owners you got to look at their percentage threshold. Just because it's not listed at the Secretary of State website isn't going to matter. It's not what it's listed as, it's what it really is. And then, Christopher, thank you. You clarified. You said when a third party registers the LLC, sometimes no members are listed. You're referring to the articles of organization that are submitted with the Secretary of State, and you're absolutely right. But it's not an issue of what's listed. It's an issue of what really the ownership structure is. And that's going to be identified in your operating agreement. Now, if you're saying, well, I don't have an operating agreement, then get one. You need, especially with partners, it is going to save your life in 100 different ways. You have to have an operating agreement. And I don't know what else to say about that unless you have more questions. Finally, this one is going to be very similar. This is an LLC with membership units instead of stock. It doesn't matter though. We look at the percentages. That's what we care about. And so both individuals A and B own 50% each, above the 25% threshold. Individual C is a manager. That's, somebody in control, and they're all going to have to report as well. So this is the fun one. This is lovely. This is very complicated, and nobody owns the company itself. What's happening here is there's two intermediate companies, company Y and company Z. And what you have to do is, remember, circles mean they have to report, triangles mean they don't. So what happens here is individual A owns 30% of company Y, which in turn owns 50% of the reporting company. So 50 times 30, let me rephrase that. 50% times 30% is 15%. 15% of the reporting company is attributable to individual A. So you would think he doesn't have to report. But I say not so fast, because look at individual A also owns part of company Z. So individual A owns 25% of company Z, which in turn owns 50%. So 50% of 25% is 12.5%. So 12.5% plus 15% is a little bit over 25%. So individual A, you sum his individual or hers individual ownership interests to get to a number that's greater than 25%, and individual A needs to report. Individuals D and E, 25% times 50%, that's 12.5%. Each one of those are considered having an indirect ownership interest equal to 12.5% of the reporting company. They don't need to report. So this can get really complicated fast, depending on the types of entities and how everything is structured. And remember the very first slide I showed you, BOI Labs, we have a free program that figures this all out. The annoying part is you got to tell the program this stuff. So you got to enter in everything, and you got to remember how much individual A and B owns in order to allow the program to do its magic. And so it's not something you can do within 5 minutes unless your company is set up very simply. But I've noticed people don't set things up properly. And so the program tries to figure that out. And it could be complicated, unfortunately. And that's maybe when you need to talk to a lawyer or somebody that can help you out further. So let's talk about exceptions briefly. There are a number of exceptions you need to know about, and I'm going to talk about two, minor child and in the jurisdiction. So I'm not a Navajo Nation lawyer. I don't know the legal rules with the Navajo Nation, but if their rules on what defines an adult, a child that reaches age of majority, if it's different from the state of New Mexico and the entity was registered in the Navajo Nation, or the minor child is a resident of the Navajo Nation, then we're going to look at the Navajo Nation laws regarding age of majority. If you have a minority or a minor, excuse me, a parent or guardian can step in the shoes of the minor and report the parents or the legal guardian's beneficial ownership information instead of the minor. But it has to be a legal guardian, not just somebody willing to do it. And then it goes away once the child reaches age of majority. There are other exceptions. I'm not going to talk much about this one. Nominee, intermediary, custodian, agent, that, it's going to apply, maybe for an accountant, tax professionals, advisors, things like that, maybe if they're doing something important with the company. But the beneficial owner that the intermediary is representing has to report. You can't put somebody in between the beneficial owner and the reporting company. Other exceptions, the big one here is employee exception. But sure enough, there's going to be some rules around that. And all three of these criteria must be met. One is they're an employee, W-2 based employee, not a contractor. And that's they get their economic benefits come from the company with their status as an employee, meaning they're not getting profit sharing or other kinds of revenue that isn't based on being an employee. And then finally, they can't be a senior officer. So you have a senior officer, manager, president, C-level person. This exception isn't going to apply to them. Finally, we have inheritor. And this one doesn't make sense to me, honestly. I don't, I think there's very few people know what's in somebody's will. And this is saying you don't have to include them. But once they inherit, then of course they're an owner. Creditors, this one is a little important. So banks, finance companies, things like that, that may have an ownership interest as a form of security in the loan. That would be an exception, provided that's their only thing. So if you had like one of the owners, a president, employee lending money to the company, they're not going to qualify for this exception because they still have other relationships to the company beyond just the issue of lending money to the company. So finally, there's this other exception. It's not really well documented in the Small Entity Compliance Guide, and I touched on it earlier, and that is if you have an entity or party that owns your company and it is actually a company that is exempt from reporting, then you don't need to know what its beneficial owners are. You could just indicate company X. And I mentioned my example earlier was the city of Albuquerque. You can mention city of Albuquerque because they're an exempt entity and you're going to be just fine. So let me talk about briefly how to submit initial reports to FinCEN. Go to that link I sent you earlier, fincen.gov/BOI. And what I recommend doing is going and getting a FinCEN ID and have everybody get FinCEN IDs. They can do that themselves, and then you can use the FinCEN ID to report the beneficial owners. That's all they want. They want the FinCEN ID, so you don't have to worry about driver's license or anything else. That would be helpful. And this is the link, fincenid.fincen.gov is where you can go and apply for a FinCEN ID. I mentioned earlier, and I'm just going to restate it, the information you need about a company, the full legal name, the trade names, where it's doing business in the United States. It cannot be a PO box or a virtual mailbox or a commercial mail. I forget what the R stands for. I want to say commercial mail receiving agency, I think is what it is. You need the tax ID. You need this information in order for the company. Now, the other thing is you need the ID of all the beneficial owners or their FinCEN ID. So if you don't have their FinCEN ID, you're going to need all this stuff, which is just, a lot of information. And legally, the company is responsible for all of this. So if you have a beneficial owner that's not willing to give their information up, that is a problem. They're also responsible for giving you the information, but the company's still at risk for fines. We got a question here. If you have already filed without the FinCEN ID, but checked the box requiring a FinCEN ID, are you okay, or do you need to do something? I think you're okay. I don't think you need to do anything more, and hopefully at some point FinCEN will send the FinCEN ID out to you so you can have that information. Carolyn asks, the fines are so prohibitive, and it seems so easy to make mistakes or miss something. Scary. Amen to that. I think these are just ridiculous, and there's a lot of gray areas. So what are you going to do with a gray area? Or worse, what happens if you have a beneficial owner not giving up their information? What are you going to do about that? So FinCEN says company's problem. Now, it's also the beneficial owner's problem, but it's still your problem. So I'm not sure what to do about that, other than if you have formation documents, employee contracts, put in their requirements that they have to provide information necessary for regulatory compliance. And if they're unwilling to do that, that should give you a reason to be either fire somebody or kick somebody out from being an owner, in my opinion. And if you're really smart about it, when you kick somebody out, you need to pay them for their percentage of the ownership company. But there's different ways to calculate it, like their fair market value or book value. And so I would argue if somebody's going to play games and you got to fire somebody or get somebody out of the ownership, Maybe you pay them book value instead of fair market value. But you can only do that if you have a decent operating agreement or shareholder agreement to govern how your company is run like that. So we're almost done. I really appreciate everybody hanging out thus far. The next big issue is updates. And it's really the same thing as the initial report. But every time there's a change in something, you have 30 days to resubmit. And all the documentation I've seen suggests that you have to file a whole new report. So if you don't have people's FinCEN IDs, you need their photo IDs and their birth dates and all this other stuff. So my suggestion is if you don't have a payroll service now, great time to get one. And I have a bit of a working relationship with Payday HCM, and we've gone over their product. And it's like, do you have these reports that can like give business owners updates when a name changes or an address changes? Or, do you have the driver's license information? And the answer, it does. So it's a great way to keep track of that information. But look at all of this. If the company changes its name or it moves, changes ownership, removes or adds a key employee, someone dies, gets married, changes their name, moves their primary residence, the ID they use for the initial report or previous report expires, all of this stuff is considered triggers that would require an updated report. So finally, getting help. Here's my suggestions. Talk to a business lawyer of some sort. The CPAs, you might be tempted to talk to your accountant or CPA. The AI CPA just recently released an opinion saying that it's practice of law and advising their accountants and CPAs not to dive into this. So you want to be a little careful where and how you get your information. And God, please, not TikTok. I'm not knocking TikTok. It's a fun thing and trying to go to bed, but unless you're listening to an actual licensed lawyer, it's garbage. I'm sorry. And this is just too important to mess up. Carolyn asks, do you know why the Secretary of State did not send out info to LLC or Corp to let people know that this is required? Look, I'm not knocking the Secretary of State. I know some people there and they're really great, but they do the bare minimum necessary as statutorily required to record this information. Do not look at them as providing any kind of advance notice or help on anything, including trademarks, trade names, or this, unfortunately. If you did business with us and we formed your company, doesn't matter when, you're going to get a notice from us and we're going to advise you. I would hope and assume that if anybody else helped you, that they will send notices as well. We're trying not to spam people, which is why we're doing things like this, but I don't know how else to get out the message. Julianne asks, what agency will enforce the penalties? FinCEN. How will they know if you don't do an update? Well, if you get sued or there's a tax issue, somebody's going to investigate. And if things aren't right, then you may have different vectors of where you could be responsible for this information. Other than that, I don't know. This is all brand new stuff. And as courts weigh in and FinCEN starts executing, we'll be able to give you more information. Anonymous says, what if beneficial owner got married at the end of 2023, and by the time they file the BI report, they've already changed their legal name? Perfect. When you file the report, it's as of the date you're filing the report. So if you had a ton of changes prior to that, that's fine. But once you file your initial report, now if there's any changes going forward, you have 30 days. So then that's where, things get a little wonky. Sandy says, oh, been terrific. Thank you. Thank you. So also there's my other recommendation, BOI compliance. There are some services out there. We sell them as well, low cost, where we'll try to keep track of all of this for you and help you with your reports, your updates. The problem is we don't know when somebody gets married. We don't know if somebody moves. The payroll service would know, but we don't have access to your payroll service. So I would recommend a payroll service and then the BOI compliance. So that would be the best options for you, but they do cost a little bit of money. Finally, is you have my program that I told you about. We have two others just saying thank you. Unless you have any other questions, I am done blathering on. I appreciate your time. And if somebody wants to unmute and ask something verbally, I'm all for that.
Lots of people saying thanks, Larry, as you can see.
Yeah, thank you for attending.
Hey, well, I don't, oh, there's one more. Is that a thank you?
Thank
Seeing
you.
any more questions? Nope. Okay.